Good morning, everyone. Welcome to the Merhab Robinson and Clarkson Estate Planning 101 Back to Basics. I'm Paula Clarkson, and I'm going to be taking you back to the start of estate planning and making sure that the basics are in place and what needs to be done to get you there. So, as you're aware, Merhab Robinson Clarkson has a couple different practice areas. We do estate planning, probate, trust administration, but we also do business law for the business owner, including entity formation, employment law, mergers and acquisitions, and everything that a business owner needs. A little bit of background about me. I'm the partner in charge of the estate planning practice. I've been practicing more than 25 years in this area, and I have a tax degree as well. So as you're aware, lots of estate planning issues have taxes regarding whether it's estate, income, or property taxes. So I enjoy that aspect of it as well. So let's go ahead and we're going to go ahead and get started. But first, I want to do a little poll because as we get started, I want to see how many people have estate planning documents in place already. So we'll just take a few seconds. I launched the estate planning poll. If you have any power of attorney, or maybe you only have some of these documents, but you don't have all of them, let me know, and just so we can tailor the presentation as well. Right, looks like most people, obviously the guardian for minor children. If you don't have minor children, you're not going to need that. But good, it looks like a lot of people have their healthcare in place, they have trust, and good. So this should be a nice refresher for everybody, and also a way for us to make sure that we have what we do, what in place, and what you need to do. So it looks like there are some people that don't have anything, and that would be great. So I'm going to go ahead and end it, and we'll go from there. I'm glad that most people have healthcare directives that have responded. So here's our results. And yeah, so healthcare directive, as you're going to see, is going to be one of the most important things. But out of the people that have plans, so we're doing pretty good on this group. But we're going to go through and explain why, what all the different documents are, and what they're necessary, and why you should have them. What they can help you with. So the first thing I think we need to start with is when we talk about estate planning. Really, what is an estate? Estate is literally everything you own. It can be your house, it can be your checking account, your car, your jewelry, your financial account, your 401k, your life insurance, literally anything that you own that someone could take away. And part of it is just planning for how does it pass when you die, who takes care of it when you cannot take care of it. So a lot of people think that estate planning is mostly for death. That is true, but we also want to do incapacity planning. As our, fellow people are getting older, a lot of people are starting to have Alzheimer's. They're having capacity issues. We know multiple people just in the last few months that sadly have had strokes, and it has an impact on their cognitive ability. So if you're in a position that you're not able to manage your financial affairs or make your own medical decisions, it's very important to have a plan in place. And that's what we're talking about: incapacity versus and end of life. We're also planning for your asset accumulation, preservation, how you're transferring it. If you have minor children, what do we deal with them? If you have beneficiaries, I mean, we all have beneficiaries, do we give it to them outright? Do we leave it to them in trust? How can we assist them with property taxes, income taxes, saving your family estate taxes, and even providing a legacy of what you have done. A lot of our families have worked so hard and created large estates and taking care of their families that they want to preserve that legacy, pass that down to the next generation, those values. And we can do that all through estate planning. So there's two different really aspects of estate planning. There's your healthcare side, making your medical decisions, appointing people, and then financial decisions. Who makes those for you, whether you're incapacitated or how are your finances handled after you pass away. So we kind of go between those. It makes it a little bit simpler when you're thinking about how to protect yourself. So I like this picture as an easy way to figure out, the big picture. You are the center of your estate plan, and you're going to have certain documents based on your specific situation. So, for example, I believe that everybody that's 18 years and older should have a healthcare directive. And, I'm going to talk about these documents, but we're going to get a little bit more into detail. But, a HIPAA release, and, a power of attorney. That's the basic, so that if, someone who doesn't have a larger estate is hurt, we do this a lot for college students. If they don't have assets that hit the probate threshold of 208,500, this is the basic. We had an incident in our firm where someone's child was in a motorcycle accident. He was 25, if you call him a child, but he was still a child. And the doctors wouldn't talk to the parents because they were the son did not have any estate planning documents in place. And the doctor was right. He's an adult. It's his protected private information. But had he had a healthcare directive and even a HIPAA, then his parents would have been able to get that information right away, as opposed to waiting a couple hours, excruciating, in the waiting room until he woke up and was able to give verbal consent. And then, when you hit that probate threshold of the 208,500 for California, then we're looking at wills and trust, and expanding on the estate plan. If you have minor children, we want to name guardians for your minor children. If you're married, California is a community property state. There's a lot of benefits associated with community property, and there's some downfalls too. So those are things that we'd want to make clear, because it could have a significant impact on the taxes associated with your family. And we'll go through those a little bit in more detail as well. So let's talk about what really happens if you were to either be incapacitated or you die and you don't have anything in place. A lot of people think, oh, the state gets all your money. That's not really true. If you are incapacitated, the probate code says these are the people that can make your medical decisions and financial decisions. And, it has a priority: spouse, children, parents, then siblings. And sometimes, especially if you're not married, you may have either a significant other, and significant others are not on that list. If you may want, if you're not married, but you have multiple children, you may want one child versus another. And the probate code doesn't differentiate on that. So there can be some squabbles between the family and could end up in litigation and things like that. So that's why we like to have you specify and not let the state decide. When you die and you don't have an estate plan, the state of California has put together a lovely plan for you. Again, it has a priority list of who is in charge of your financial estate, the probate. And then there is also a list of where your assets go and who they go to. So the assets do not go to the state of California. They can even go to very, very long lost relatives. We did that recently with a woman in her 90s, not married, no children, parents deceased, sibling deceased without children. And we were going down to like third and fourth cousins. I'm sure these people had never even met her, but they did receive a portion of her estate because that's what California law says. So doing an estate plan really puts you in control and not having to follow the plan that California put together for you. So as I mentioned, during your lifetime, the court will get involved in what's called conservatorship or guardianship. In California, every state's a little bit different, but California, we have a differentiation. If you're under 18, it's called a guardianship. If you're over 18, it's called a conservatorship. And we get guardianships where, grandma and grandpa think it's a good idea to leave $100,000 to their 10-year-old grandchild. Well, if they don't leave it to their grandchild in a trust and they want to leave it to them outright, the parents are unable to collect that $100,000 without opening up a guardianship. So the court would get involved, the court will oversee how the parents spend the money, and then the child gets it when they're 18, which may or may not be the parent's ultimate plan. So we'll talk a little bit about how we can use trust to follow those plans. And then the conservatorship is when you're an adult and someone is appointed to manage your personal, your healthcare and your financial affairs. I mean, I think that the most recent, biggest thing that we've heard, was Britney Spears, that other people were appointed to manage her financial affairs, and then the court oversees it. So there often is a lot of expenses associated with that. So, and we talked about probate. After you die, how does the court get involved? The probate threshold today is 208,500. So if you had, like we talked about, that young adult, the 25-year-old, they're just starting out in their career. Maybe they own a car, maybe they have $10,000 in the bank. In the worst case scenario, that child dies, they are under the probate threshold. The probate code does say that their assets would be divided equally between their parents or all to the surviving parent. And then if their parents are deceased, it would go to, well, first it would go to their children and spouse, and then it would go to siblings and things. So those are things that we'll talk to young adults about and see if they're comfortable with the state plan. But the great thing is, if you're under 208,000, we don't have to go through probate. And ways to avoid that, especially like for the young adult, is if they have a 401k through their job, naming beneficiaries, or potentially a smaller account, naming a payable on death beneficiary, so that payable on death is kind of like a life insurance beneficiary, but for more of your checking account, savings account. And then, the probate process is just proving that your will is valid, notifying creditors, providing an inventory to the court. But unfortunately, with the court delays, it can usually take a year to a year and a half, just between, when you file the initial petition to be appointed. We usually don't have hearings in Southern California for 45 to 80 days sometimes. And then right now we are at the end of a probate, and when you're done with the probate, you're supposed to file a final petition, confirming to the court you've done everything you're supposed to. The beneficiaries get to see the accounting and so forth. We have one of those right now that we filed in November, and our hearing date isn't till May. We are completely done with the probate, ready to distribute it, and we're basically having to sit still until we can have that hearing in May. So that's where a lot of the delay is. So if we can avoid that to get the assets to the beneficiaries sooner, that would be great. Because during the probate process, the beneficiaries can't use it. And in this case, it was two surviving children. They literally have no access to spend the money, use it for their own, living expenses or education and things until the probate is completed. So, as I mentioned, we have the time lag for reasons to avoid probate. There's also privacy issues. If you look at TMZ or any other media outlet like that, whenever somebody passes away, a celebrity, if they have to go through probate, we can see their will because it's all out there for everybody to see. The inventory is all out there, so we can see what their assets are, who gets what, and things like that. Probate is also kind of expensive. There is a statutory formula for how the executor of the estate and the attorneys get paid, and it's based on that gross value of the assets. So it's a sliding scale, 4%, 3%, 2%. If you have $1 million estate, the attorneys get paid $23,000, and that's statutory, and it goes up from there, regardless if it was one house or one bank account. That's very simple. Even if you had a house and it had a $900,000 mortgage and is valued at $1 million, the attorneys still get that share, and the executor gets the same amount of money. Also, I think that one of the biggest costs with probate is not being able to finish it. You've lost a loved one, now you're thrown into doing this. If you can't close the probate, move on for this for a year and a half, you might delay the grieving process or having to live in that on a regular basis. So avoiding probate for your loved ones can help them with their mental grieving and get to those processes faster. So there are multiple ways that you can transfer property when you die, and some that we use even when we have a full estate plan. We have operation of law. That's where you name something like in a trust, that you have it for their benefit. Sometimes people will buy property in joint tenancy or as community property. And when you have joint tenancy and community property, the assets go automatically to the surviving joint tenant. I'm going to get into a little bit more detail on those. It's basically when two people own the property together. There are other ways too. You're all aware of, contracts. If you have a life insurance policy, a 401k, employment benefits, that name a beneficiary, then those are by contract that you've designated. Sometimes like your employer will say, we'll give your family the life insurance when you pass away, or, and if you're married, then you're required to name your spouse as beneficiary of your 401k unless they waive their rights to it. So those are more of a contract type of thing. So as I mentioned, joint tenancy is a way for two people to own property together. So it could be husband and wife, like me and my husband can own a piece of property as joint tenants. I die, he automatically gets the property, no probate necessary. But it can also be owned with people that are not your spouse. It can be owned parent-child. It can be owned friends, other family members. It's basically open to anyone. There's some rules that they have to take the title at the same time. They have to take the same interest in the title. So for example, if you had two people as joint tenants, they each technically own an undivided 50% interest in the property. If three people take title at the same time, they own a third interest in the property. And so what happens is, if I die and the property's in joint tenancy, yes, it does automatically pass to my husband, and there is no probate, which is a good thing. But now the property's in his name. And if he dies, then the property would be subject to probate, because there is no additional joint tenant. So that's where we end up having some problems. It also means that if I die and leave it to him, then he can do whatever he wants with it. I'm in a second marriage, so we have different children. So maybe I want to have him live in the house for the rest of my life, but I want, when he passes away, I want some of the proceeds to go to my child. But if I do joint tenancy, then it automatically 100% ownership goes to my husband, and he gets to choose where those where the beneficiaries are. And if he were in a position that he did not do an estate plan and died, the probate code does not say that his stepdaughter, my child, is a beneficiary through probate. It's only his children. So sometimes there's inadvertent disinheritance. Maybe he did it on purpose, maybe it was inadvertent, but that's where you lose some control over it versus having it in an estate. Sometimes there's gift tax complications. I'll often have parents say that, well, I just want to put my son on title of my house, so that when I die, it can pass to them. Well, when the parent who's owned the house then deeds the property to parent and child as joint tenants, the parents have just made a gift to that child. So the parents have gift tax consequences. There could be property tax changes because you've made a gift and changed ownership. So there's a lot of other things to think about by just throwing someone on there. You can't avoid a conservatorship with a joint tenancy. So going back to the example, if my husband and I own the piece of property, but I end up with Alzheimer's, he doesn't have any authority to borrow money on the property. He doesn't have money to sell that property. And that could be a problem if we needed to have that money for other reasons. He would have to go to court to get a conservatorship over me so that he could manage my part, and then obviously him having capacity, he can manage his part. So you don't necessarily avoid conservatorship and can cause problems. We also have another pitfall being basis adjustment. So basis adjustment is a tax issue. When you buy a piece of property, that is your basis. So purchase price plus any improvements that you made in the property. So if you were to sell the property during your lifetime, you have sales price minus your basis will determine if you have capital gains tax. But we have this great thing that if you own property, whatever you actually own when you die and that is subject to estate tax will get a basis adjustment. So again, if my husband and I own this property together and I die, only my 50% of the property gets a new basis, which will eliminate capital gains tax on my 50%, but not on his. And you'll see if we own this property as community property, then only one of us has to die to get 100% basis increase. So that can save a lot of money if he were, for example, to downsize after our marriage or need to sell it to move closer to one of the children or different things like that. So one of the other documents that we have, I think is one of the most important, is your healthcare directive and your HIPAA release. Really, anybody 18 years and older should have this. And it basically allows you to nominate someone to make your medical decisions for you when you can't. So, a lot of times, like I said, you have people in your family, you could not be married, and it could be a significant other. According to the probate code, they have no authority. You have to do a document giving them authority. You could give the authority to two people. If I have two children and I want to name both of them, or I want to name my child that lives closest to me, or the child that might be in the medical field. There's lots of reasons to name one person versus the other. So, I know I want to have the person that I feel most comfortable with making those very intimate decisions for me of who's caring for me, what type of support I'm going to need to do. And then, and having access to all my medical information, because that is really private that you don't necessarily want to share. Also, within your healthcare directive, you're giving them options. You're telling them, when I do pass away, do I want to be cremated? Do I want to be buried? Do I have preferences? If I'm cremated, do I want my ashes spread somewhere? Do I want my urn to be buried? Do I want to be buried with my spouse? What do you want to do? Especially, sometimes people don't, they might want to go back to a family plot that's in a different state. It's really good idea to specify that in your documents so that your family members are not wondering what you wanted, and number two, arguing about it, because everybody has different opinions, as well as donation of organs. We hear the gamut, and there's nothing wrong. Lots of people like to keep their organs, that they don't feel comfortable sharing them. Some people want to share them for transplant. Some people want to share them for research and education to help, if they have an ailment that could potentially help. And everybody has different preferences. So we want to specify that so that your agent isn't the one, or your children are not providing their preferences. It's what your preference is. And then in the healthcare directive and the HIPAA are two different documents. The healthcare is spelling out all this, and then the HIPAA says who the doctor can talk to. So, for example, I might say in my healthcare directive, I want my husband to make my medical decisions, but in my HIPAA, I can say I want my husband and my daughter to be able to talk to the doctor and get my protected medical information. There's only one actual decision maker, but I'm allowing multiple people under the HIPAA to be able to access that information. And sometimes there's lots of reasons you want various people to have it. Going to the financial side of things, we want to talk about first a power of attorney. So, a power of attorney is someone that makes medical decisions or financial decisions for you. They are stepping into your shoes and acting for you. And this is really only when you're alive, because when you pass away, your power of attorney doesn't work. And that's why it doesn't have anything to do with transferring your assets. So, if I become incapacitated and I have a power of attorney, anything in my name, whether it is like the joint tenancy assets, dealing with my taxes, Social Security, if I have a 401k, calling my credit cards, collecting my mail, my agent on the power of attorney will have that authority. Now, when we have a trust, then the power of attorney and the trust work together. So as we'll discuss in a little bit, the trust should hold most of your assets, your real estate, your investment accounts, but things like your retirement plans, 401ks, IRAs, Roths are not allowed to be held in the trust. So when you have a trust, you have both, because if I'm incapacitated and my Social Security checks are now I'm of age, making those elections, my agent under the power of attorney will be able to make those elections for me. Usually we're going to make the person who is your agent on your power of attorney the same person as the successor trustee, so that they are dealing with your money wherever it is. But you can see that you can have a power of attorney and not have a trust. And you can technically have a trust and not a power of attorney, but most of the time you will have them together. So it is a very important part of an estate plan to make sure that you don't just have a trust and not a power of attorney. And this is where we'll have a lot of young adults that don't have estates that are necessary for a will or a trust, because they're, like my daughter's 19, she doesn't have any assets. But, I still have a power of attorney, because if she were incapacitated, I may need to apply for some government benefits for her. She has a job, so I may need to, get her paycheck and get into her bank account, do those types of things, get her mail. So having the power of attorney will allow me to do those financial things for her without having to go to court and get a conservatorship. It's automatic that I'm there. When you have minor children, it's very important that you name a guardian for them. And this is an important part of a plan. There's a couple places that you'll name guardians. One will be if you have a will, but the will is usually only probated when you die. So we also do a separate guardian nomination for you, that if you were somehow incapacitated, that you're naming the people that you want. Now, this guardians for minor children are a little bit different in that the court does have to get involved, as you can understand, because children are involved. But when my daughter was a minor, I named someone to be her guardian. So that guardian is not necessarily the person that's going to manage the money for her. It's the person who is going to raise her, the person that she's going to go live with. They're going to make the decisions on her education, maybe religion, healthcare, things like that, until she's 18 years old. So you're usually going to want to pick, close family members, people that have your same religious, educational, financial beliefs, maybe someone that is close to, in location to you. If you have a child that is in high school, we've had people that have children that are in high school, and they name, a good friend, like their children's best friend's parent, because they know if something were to happen to them in those last couple of years of high school, maybe they don't want their child to move across the country to live with, their sister or something, the parent's sister. But if the child is like 5 years old, that's not a greatest impact. So those are always really important things to think about. And we always want to have backups. A lot of people will name their own parents to be in charge of their minor children. But our parents get older, and depending on the age gaps, if something were to happen, your parents might not be in a good position just because of their age, their own health, and things like that. So there's a question about, is the healthcare directive enforced, or the HIPAA? Yeah, the HIPAA is valid under California and federal law. So it's providing the document and showing it to the medical provider to get that information. It's not registered. It's something that the individual who created it will have, and then they can share it with the people that they've nominated to be in charge. And usually when we do for our family members, we will make them wallet cards. And so on one side, it'll say like, here's our healthcare directives. When we have minor children, we have on the back, here are minor children, please call them, that we'd like them to carry in their wallet. Because, I'm assuming you're not walking around carrying your full estate plan with you on a regular basis. And if you were in an accident and you were unconscious, the idea is that the paramedics or other medical personnel is going to be opening your wallet to figure out who you are. If that document or the little card is right behind your wallet, then, oh, it's like, wait, there's minor children. We got to deal with this. Here's people to call. We put the person's name and their phone number on there to help them with it. But, when you have the guardian, it's really important. We all have family that, I know, for example, like in my family, there are people that think they would be the best one to raise my child, and I know they would not be. So, having the list, having your wishes there in a form that you can speak for yourself when you're not able to speak is a really good thing. So once you can have a will anytime, but a will is basically a document that does transfer your assets when you die. You get to name an executor who's in charge of it, and you also get to name your beneficiaries. But when you only have a will, then you have to go through probate still. So unless your assets are less than the 208,500 or pass automatically like a beneficiary designation. So, when we go back, it's, if you have no plan, you're still going through probate and following the California lead. If you have a will only, you're going through probate, but you get to choose your executor and beneficiaries. And if you have a will and trust, generally you're going to avoid probate because your assets should be funded to the trust. Now, I say generally because we do have occasion where sometimes people forget to put beneficiaries on things. We recently had one of our clients, their parent passed away. The parent had a trust. Almost everything was funded in the trust, and they forgot to name a beneficiary on their retirement plan. So we had to go through probate just on that retirement plan because it exceeded the $208,500 limit. So we'll talk about it a little bit more later, but it is really important that when you do have a trust that you review these things. It's a great time every year when you're doing your taxes. Double check the beneficiary designations. Make sure your assets are in your trust. You may have bought a new house, you may have changed jobs, you may have changed insurance, you may have bought new insurance, you change financial institutions. So always double check these. But our goal when you have a full plan with a trust, our goal is that the will is just a backup, and that if something accidentally got kept left out, that we go through the probate on. And for example, in our other situation, just that one asset. And when you have a trust, your will say the beneficiary of the trust or the will is your trust. We call it a pour over will, so that ultimately everything gets back into your trust and you have one document that details who's the beneficiary, how were things distributed. Now, there's a question that says, can I DIY my will and estate plan? You can DIY anything you want. We can DIY, fixing our car, we can do plumbing. The concern is, in some cases it's probably going to be fine, but there are a lot of issues and laws associated with it, especially if your family is a little tricky, making sure that you're complying with all the requirements. So for example, in California, the power of attorney, the healthcare directive must be notarized, but the will is not. The will has two witnesses. The witnesses cannot be people named in it cannot be the family members, cannot be the executors. And those are a lot of the areas that we see problems. They may not have a no contest clause, which could be a real defining factor if there was some turmoil in the family, was fighting over your assets. So those are some important things. We also, I'd say, probably at least every meeting that I have with a client and we're designing their plan is, oh, I never thought of that. I never thought of that. So we see the good and the bad and the ugly and the different types of families. So our job here as your advisors is to go through, once you tell us what your goals are, to say, okay, have you thought about this? Have you thought about this? And kind of play devil's advocate to make sure that you're considering all the different aspects of it. So, oh, I'm sorry, I forgot. I didn't update this number, but do you need more in your plan? So assets less than, it used to be 184,000. It got bumped up last year to 208,500. So you can have a little bit more money. As I mentioned before, young adults, we want them to have at least the foundational plan of the healthcare directive, power of attorney, HIPAA. And sometimes even just older adults. We have some clients and they tell us, hey, my mom just has a bank account. Great. Then we'll work with them and say, okay, let's make sure mom has maybe a payable on death beneficiary, or so that mom can, name the money can transfer. We want mom to make sure that mom has the healthcare directive. And if mom is incapacitated, someone being able to pay her bills. And then if you need more, then we look, if you have minor children, we're going to want to name that guardian. If you have assets greater than the 208,500, we're looking at wills and trust. If your beneficiary has special needs, we want to consider, not giving them the assets. They might not have the ability to manage it. If they don't have the ability to manage it, does that throw them into a conservatorship where someone is managing it for them and now the court is involved? Or does it, and then because they now own these assets, are they not able to qualify for government benefits that they otherwise would have been able to qualify for before they spend down this money? Are there beneficiaries that are outside of your family? It could be charities, it could be good friends, different people, significant others that, are not necessarily provided for in the California estate plan that is created. So those are all considerations for wanting to do your plan. So I guess the big kahuna of the estate plan is your living trust. So the living trust is basically an agreement that says, I'm entrusting this person to manage my assets for these people. And while you're alive, you are entrusting yourself to manage it for the benefit of yourself. So there are three parts to a trust. There is the trustor, which is the creator, and that will always be you. And then there is the trustee who is managing it. And for the most part, it's the same person. And then the beneficiary, and generally it's you until you pass away. And then it could be your children, charities, other people. So while you're alive, we create the revocable trust. And again, all of these documents are revocable while you are alive. As long as you have capacity, you can change them. Because obviously, when the 18-year-old creates their healthcare directive and potentially names their parent, once they have significant others, they may change it to them, get married. If their significant other passes away when, they're in their 70s and 80s, at that time, they may name their child. There's different life situations where they're going to make changes. So these are fluid documents that should be updated and reviewed periodically. So, it deals with it avoids conservatorship, because if I have a trust and my assets are in a trust, I become incapacitated, then the trust provides, okay, here's my next trustee that can step in. I'm still alive, so I am still the beneficiary, but this person is able to manage my assets. So, for example, if my house is in my trust, which it should be, then my trustee may have the decision to sell the house. They may be able to refinance it. We've had older, people where their successor trustee, their child, refinances the house so that mom is able to, or, stay in the house, do a reverse mortgage. My house might need to be sold because I will never be able to live alone again. I need to be in an assisted living for the rest of my life. Different things like that. So it allows all of that to take effect without the court being involved. And it allows the person that I have chosen to be the one that takes over, not somebody that the state of California has chosen. So when you have the trust also, you are able to protect your beneficiaries. So as I, my daughter's 19. So, legally she's allowed to take money. I could leave my assets to her. Would I do that? No, I think she's too young to be managing them. So, is it something where I say, I want someone else, even when I'm gone, she is the beneficiary, but I want someone else to manage it for her until I think that she is an adult and financially mature. And, that might be 25, that might be 40, that might be never, depending on the person. If the beneficiary has special needs, if it's in the trust, we can build in special needs provisions that allow that beneficiary to inherit the assets. They're in this trust for their benefit, managed by somebody of your choosing, and they are still able to qualify for needs-based government benefits. So that can significantly help your family. There could be ways that we have sometimes trustees or parents will say, children, you need to get X grades in school, or we will give you certain money at certain milestones. If you graduate, from university, we will give you a bonus at that time, different things like that. So you can pass along your values in different ways. Obviously, it has to be legal and to do that, but you can give them incentives and things like that. And then also provide for others and charities of your choosing, if you'd like to show, what things were important to you during your life. Estate planning is very much tax planning as well. So as I mentioned earlier, we were talking about joint tenancy and the basis issues. We want to look at capital gains issues, because if we have a husband and wife and they're looking at downsizing, but one spouse is really ill, it might be that you need to wait until, sadly, one of those spouses dies and we get a basis adjustment. I know my parents bought their house in 1973. They're going to have a ton of capital gains tax if they were to sell it today. But sadly, if one of them passed away and they own the property as community property, because we are in California, that's one of the benefits, then they get 100% basis adjustment. If my mom were to pass away, my dad would be able to get a new basis as of her date of death. And then if he sold the property shortly thereafter, he could have little, if any, capital gains tax, be able to take that money, downsize, move somewhere else, and things like that. So it can save a ton of money for your family. And that helps with, the income taxes and things. There's issues that we need to look at with property taxes. Prop 19 changed the scope of property tax significantly in California. So I'll kind of go through, there's a couple of things, people get it confused. Prop 13 is the law that says when you buy a property, you get the basis, which is what you paid for the property. And Prop 13 says that they can only increase it no more than 2% every year. So I know sometimes we have years where property in California will appreciate significantly. Even if your property is increased significantly, they can't do that. So going back to my parents, they bought their property in 1973. I guarantee they do not pay property taxes based on the current value of their house. They go back to 1973 and the little bit that it's been able to be increased every year. So that's a significant savings for them. But what happened with Prop 19 is now there's a lot of restrictions. So when they pass away and that property comes to me, there are only some situations where I get to keep their property tax. So because it's their personal residence, if I were to move into that and make it my residence within a year of the death of the second of them, then and make it my new personal residence, I can keep their property tax within a formula. I use an easy example. Say that their property tax basis is $300,000. Well, I can take the next million, so a value of the house up to 1.3 million, and I get to pay property taxes at their level. But if their house was 1.5 million, current fair market value, I pay property taxes at 300,000 for the first 1.3 million. And then the difference, the additional 200,000, I'd pay property tax increase. So where my parents on that same house would be paying 300,000, if I moved in and made it my residence, I can pay property tax at $500,000. It's more than them, but it's definitely did not get readjusted to the $1.5 million value. So it's still a significant savings for me. So there's a certain formula. Now, if I took that property and decided that, I don't want to live in it and I want to rent it out and keep it as a second property, I can do that, but my property tax will be reassessed based on the current fair market value of that property. So those are all decisions to make when you're deciding, who to give property to, can they afford it, if they're going to move into it, if they're not, and things like that. We also have to think about estate taxes when we're doing estate planning. There are two different types. You have to look at the state the asset is in, as well as the federal number. So California does not have an estate tax, which is one of the only taxes we don't have, and that's a really good thing. And then the federal limit starting this year, it's now $15 million per person. So each of us can transfer $15 million without estate tax, and we don't have an issue. And when you have a couple, that could be $30 million. But then you have to look. And so let's say that I have property in a different state. I have a vacation home in Arizona. Then that property in Arizona could be subject to Arizona's state estate taxes. So you always have to look at the big mix of what you have. And then gift taxes are correlated with the estate tax. So the 15 million I can pass when I die, I could choose to actually pass that when I am alive. So let's say that I had a large estate and I decided today to give my daughter $5 million. That's great. I can give away $15 million gift tax free. But that means that when I die, because I've already given away five, I can only pass $10 million estate tax free when I die. So then let's see. So there's a lot of different things to consider. And the estate tax rate is 40%. So if I were to pass away and had an $18 million estate as a single person, $3 million would be subject to 40% federal estate tax. This year we have the gift tax exemption. The amount you can give annually every year without incurring any gift taxes is $19,000 per person. And that amount is, when you talk about gift tax, the recipient is never subject to gift tax. It is always the person who's paying that could be subject. And the rules are, if I gave someone 15,000 cash, I just wrote them a check, I don't have to report it. I don't have to do anything. I don't have to report it to the IRS on a gift tax return. But if I wrote that same person a check for $25,000, then I've gone above the limit. I'm required to file a gift tax return. And the first 19,000 is free, but the $6,000 difference reduces my 15 million that I can pass when I die. And I'm not going to be able to do that math in my head, but it reduces. And then you file gift tax returns and you keep track of that. So, but in some cases, there's good reasons to use that money while you're alive as a way to get appreciation out of your estate and things like that. We have another tax called generation skipping transfer tax. And that's when you were to pass assets to someone who's more than one generation below you, like grandparents or grandchild. It could also be from someone who is not in your family line that's 35 years younger than you. So maybe if you have a good family friend or something that is, 75 years old and they want to give it to a 20-year-old, then that would be subject to what we call generation skipping transfer tax. But the first 15 million is GST tax free, just like the first 15 million for estate taxes. And then there's the tax on it if it goes above and beyond. So here's just a simple example of distributions. You have your revocable trust, and then you pass away. Let's say you have minor children. We might want to, because they're minors, we would want to hold it in trust for them. We often call those dynasty trust, where you're naming someone else. You have a trustee who can make distributions of income, can make distributions of principal, can manage those assets for your beneficiaries. And there could be times when you want them, when they're 18 that they get it, when they're 25, 40, whatever it is, or maybe never, because you get some asset protection by holding it in trust for them. And then, especially if you leave it in trust for them, you can say, when my child dies, I want those assets then to go to my grandchildren. I don't want my daughter to be able to give it to her spouse. I don't want her to be able to give it to her friends or the charity of her choice. So those are all things you look at when you're creating the trust. How do I give it to my beneficiary? Do I give it to them outright? Do I give it to them in periods? Do I give my child, a third of it at 25? Maybe I give them a little bit more at 35, the rest of it at 45, thinking that, one, I don't want them to have all this money at one time, but if they were to blow it or not be as financially responsible with the money at the beginning, they haven't kind of gotten rid of all of it. So there's lots of things, and those are things that we talk to you about when we're designing the plan that you might not consider if you're doing the plan yourself. When you're married, we have to look at a lot of other things, especially if you're in a position where there's tax or potentially second marriages. I use the example before, if I have a revocable living trust with my spouse and I die and I leave everything to my spouse, the trust is still revocable. He could technically change the beneficiaries and intentionally cut out my child. Where if we had a revocable family trust, and when I died, the trust splits. So if my spouse is a surviving trust, he gets his portion of the assets over here. It's revocable. He does what he wants with. But my side, since I'm the decedent, can go into an irrevocable trust where I can designate I would like my spouse to, continue living in the house, maybe able to live off the income and so forth while he's still alive. But when he dies, I want it to go to the people that I say get to go to it, be the beneficiaries. My child, he does not get to disinherit them. So, and these are also great ways to deal with, tax savings and being able to use that $15 million dollar exemption for each spouse. So we look at those, but you still have, the trustee giving money to the surviving spouse, giving money to the children, and looking at the big picture. So sometimes the trust can be, complicated, but we have to look at them at the different levels. The first level being, while you're alive, what happens? The second level is, if you're married, what happens while your spouse is still alive? And then the third level is, okay, after both spouses are gone, how does it go to the next generation and then the next generation? And that's ultimately how you're planning. Having the trust is just step one, and creating the plan and getting it written is literally only step one. You will not avoid probate or have proper management of your trust unless your assets are in your trust. So think of your trust as the treasure chest. We retitle your real estate into the trust. You want to retitle your bank accounts into the trust. Life insurance, usually the trust is the beneficiary. Retirement plans, maybe not, because there's tax issues with that. So those are things we'll discuss with you based on your personal goals. We want to assign your personal property to the trust so that, when I die and I say all my personal property goes to my daughter, that means that she gets my jewelry, she gets my shoes, things like that. My purses, all my fun stuff. So it's always a good idea, like I said, think about it when you're acquiring new assets, you're changing bank accounts, you're moving houses, buying a second house, whatever. Do I need to do something with and put this in the trust or not? At least annually take a look at these again. I always recommend that, for your retirement plans, your life insurance, that you keep a copy of the beneficiary designations. We've had numerous times where maybe I had life insurance with one company, they merged over time with another company. My policy was still in effect, but when I died, they lost the beneficiary designation through the merger somehow. So it's really important that you keep accurate records of your own just to back up those things. So when we look at the estate plan, we're looking at the big picture. I think going back to that you are the sender of your plan. I'll take it back here. Is the biggest thing. What type of plan do you need for the stage of your life that you are in? And we plan for that. And like I said, it's revocable. You change it as you get older, as your life changes. It could get simpler. It could get more complicated. And then oftentimes it does get simpler too. So looking at and growing with you on where you're at. So we have a few minutes. So I wanted to see if anybody has any, whoops, a daisy, any questions that you wanted to go over and that I haven't answered yet. It looks like there were a couple in the chat. Let's see. Someone asked, what is your perspective on the statutory power of attorney in healthcare forms? They're statutory, so they are legal. I think that they're a little generic. I like to beef them up a little bit. I know the statutory form, for example, like on the power of attorney, it'll say it lists like 15 different items and it says all of these. So, but it has like a line item. My agent under the power of attorney can deal with real estate, can deal with, my estate planning documents, can deal with bank accounts. I like to specify, well, when I'm talking about real estate, what am I really allowing them to do? Am I allowing them to buy, to sell, to refinance? Or maybe I don't want to give them certain powers. So I like it to be a little bit more detailed, and with the healthcare to specify, anything that you may want. We'll have clients say, I want to be buried here. I want, I might only want to be kept on life support in this situation, but not in these, based on their own past experience with other family members. So the statutory forms are valid. They're legal. I think that they're more on the vanilla side, that they could be beefed up. There's another note that says on property tax, if someone passed away in July 25, when would you start your 6 months and a day primary residency? It's not 6 months. It's within 1 year of date of death, the beneficiary needs to make that their residence. So, and there's also documentation that needs to be filed with the county that shows that it is now your residence and things like that, to go within that parent-child exclusion that we talked about, if you're able to take over some of your, take your parents' property tax level. And there's a question about how much does it cost to set up a trust? Is it based on the assets? Usually it's not necessarily based on assets, other than if, we'll have some clients that have one, most of our clients have a house that we transfer in, that's part of it. But if you came in, you had 10 houses, 10 properties, that obviously costs more. We're dealing with different deeds and different work and things like that. But for the most of our clients, creating a full estate plan with the will, the trust, the powers of attorney, healthcare directive, we're looking in the $4,000 to $7,000 range. The differences based on, are you single? Are you married? Are we doing special needs planning? Does your child have addiction issues? And we have to draft it and do all these custom things to it. What type of planning are we doing? And then this is what we talked about today was basic estate planning. We have not talked about, if you are above that $15 million threshold and doing some advanced planning, that's a whole different topic. But, we start always with the beginning, and then there could be additional plans. There's another question of, do you have experience with international families? It's a little vague. We have experience where we have a lot of beneficiaries where their beneficiaries live out of the country. You know, we have some in Canada. We're dealing with a whole estate right now where all 6 of the beneficiaries are in the United Kingdom. So there's issues to deal with that. We also have clients where they have assets here in the United States, but they also may have assets in another country. Usually what we will recommend if you have property here and another country, that you seek legal counsel in the other country as well, because we have learned not every country will accept a United States wills and trust. For example, I had a client that had assets, I could draw a blank on the country, but they don't know what trusts are. They don't accept trust. So you want to make sure that your plan as a whole is complying with both the where the international property is, as well as the United States. Now, that estate tax that we were talking about is based on your worldwide assets. So when you're looking at the federal estate tax, that's the number. You do get credit if you were to pay estate tax in a foreign country. It would reduce potentially any state taxes that you owe here. And then there's another question: if you were set to inherit a sum of money, should you set up a trust before getting the money or wait till after? If you were going to inherit your money outright, I think it depends, because they can kind of be done simultaneously. I think it just depends on your situation. It never hurts to set it up ahead of time, because, you know, it's in place, it's there. We'll often have a family member where, you know, maybe the parent died and the child is inheriting, you know, and I say child, I'm thinking, you know, 30, 40, 50-year-old, and maybe they don't have their whole plan. But you know, when someone dies, you don't automatically just get their house and a check. Usually it takes a couple months, because we got to make sure that their bills are paid, their final income tax return is paid. So there is some time there for that beneficiary to create an estate plan. And especially like if we're helping on both sides, we can do that really quick and make sure that when that, for example, that house comes out of mom and dad's trust, that we can deed it out of the trust and into the child's new revocable trust. So it really just depends on the situation, but it can be done very, very quickly. So it looks like we're done with the questions. I don't see, and we're out of time, but I wanted to give you a heads up that next month, our webinar is just going to be Ask the Attorney. We know that there is a lot of questions that have to do with funding, to do with lots of situations. If you look at the QR code, you know, and download it, we have something where you can ask the question ahead of time, or if you wanted to, you know, so you can do it anonymously, or if you wanted to, where we'll send out an e-blast as well on our website, and, you know, Facebook, Instagram pages will be advertising it as well. Or if you want to, just feel free to email us. We're always happy, and we can throw those questions in just to make sure that we're answering the topics that you have in mind. So we will send out the webinar, the recording to you shortly, but we thank you for joining us, and we look forward to helping you. We try to help you plan so that you can live in peace, and that your assets and your legacy can be passed on in the most tax efficient and peaceful way for your family after you're gone. Thank you all, and Happy New Year to everybody.